All right, let's get started, everybody. My name's Professor Ben Alarie, and I'm really happy to be here hosting a webinar with you all on predicting judicial decision-making using machine learning with machine learning. Our topic today is this area that a lot of practitioners really struggle with, and it's one of those gray areas where it's really hard to know how to proceed in terms of giving advice about how to characterize different gains that individuals may have in buying and selling things like corporate shares or bonds and that sort of thing. So the goal today is to talk generally about our approach to using machine learning to predict how courts will decide these sorts of gray area tax questions. And we're going to dive into a little bit about the use cases, when you might use software like this, when do you turn to machine learning in tax, when does it make sense to do that? And then we're going to jump into a particular case and see how you might address it using Tax Foresight. If you were a practitioner and looking to provide somebody with advice, how might you best go about informing the advice that you're going to give to a client using machine learning? So this is a really exciting webinar for us to put on. We started these back in 2017, about midway through last year, and they've grown really, really popular. So we now have about 5 times as many registrants for these latest webinars than compared to the start. I know a number of you are repeat visitors, so it's great to see a number of you coming back. And for those who are new, welcome, and I hope you'll tune in future episodes. So let's get started. Just to provide a little bit of context and to situate the conversation that follows, I think it makes sense to explain where I think these kinds of research tools fit into the arc of legal research tools over time. Back in the 70s, 80s, 90s, all legal research was basically done using hard copy materials in different kinds of libraries, law libraries, tax libraries, and it was all in hard copy. If somebody else had the volume that you were looking for, you were out of luck. You basically had to wait until they returned it, were done with it, or you may never actually be able to do the research, a complete job of research that you wanted to do. That all changed with the advent of digital research tools. So by the late 90s, early 2000s, we really started to see digital research tools take over from their paper-based counterparts. Lots of advantages of digital, of course. One is that you don't have that exclusivity problem that you have with paper-based resources. Multiple people can look at the same digital document at the same time. You don't have to worry about somebody checking it out of the library and then you being left without being able to do complete research. And better finding tools, so you can actually find stuff really fast in a digital database compared to paper-based resources. At least many times that's true, especially where the materials are properly hyperlinked and indexed. You can find stuff super fast. No card catalogs for digital resources, unlike the ones that I grew up with as a grade school student, and even into university. There were physical card catalogs of topics and resources that touched on those topics. That all went away with digital. And essentially every big business now, every big law firm, every big accounting firm, every government agency that's using legal research tools has moved away from emphasizing paper-based materials. It has moved into digital-based materials. In some respect, that's an amazing change. It's happened within 20 years, this complete change from paper-based stuff to digital stuff. I think the next 20 years are going to see an equally wholesale change towards computational research tools. And that's basically what we're going to be talking about today. How does this work now? And what can we look forward to in the future as these computational tools really grow in scope and coverage and become more refined and more exciting to get things done? Basically, the computational approach moves beyond taking things from a book and moving it onto a screen and says, okay, if we've digitized this stuff, it's all in the computer. Can't we possibly use massive computing power, algorithms to figure out what it all means? So why should humans have to read from the screen all the materials that they would have in older times read from a book? why don't we synthesize the content of those materials and allow the human to really leverage the fact that all these things are digital? So you might call this different things. Predictive analytics would be one approach, machine learning, artificial intelligence. These are all words that gesture at this computational turn in legal research. And Tax Foresight is just one example of these kinds of computational tools. They're going to be everywhere. So the way that we approach this job in Tax Foresight has a similar structure to how you might think about judges deciding cases. And so in law school, when I'm teaching law students, we spend a lot of time talking about the facts of the case and how they're found by the trier of fact. And the trier of fact is typically the trial judge. So the trial judge has the benefit of listening to all the testimony of the witnesses, looking at all the documents, assessing the probity, the honesty of the witnesses, assessing the quality of the documentation, how legit they feel those documents are, and they come up with a narrative of what actually happened. So this is what we're describing on the left-hand side as the facts. So the judge finds the facts. And then in law school, we spend a lot of time focusing on, okay, so we've got these facts. This is what happened in the world. How do we make sense out of those facts legally? How do we characterize certain elements of those facts? How do we apply legal tests to those facts to produce what ultimately is of interest to litigants and to those who are operating in the shadow of the law, which is the legal outcome? And so spend a lot of time picking apart legal reasoning, analyzing different ways of thinking about legal tests, looking at conflicting lines of cases and how one might reconcile those lines of cases, and look at how judges basically treated those facts to get to the outcomes that they announce at the end of their judgments. So in Tax Foresight, what we do is look for the user to supply those facts. So the user is essentially performing the role of the trier of fact, providing a bunch of facts to the system. The system will elicit those facts from the user, ask all those questions, get the facts. The user makes up essentially the story, the narrative, what actually has gone on. And then we use machine learning to map those facts onto the most likely outcome that a court would have produced had a court been confronted with those same facts. If a judge had found those same facts that the user provided to the system, what is it that a judge would have likely said in those circumstances? And so our methodology allows us to have about 90% accuracy on average with respect to these different gray area questions, which is actually really, really great. I mean, on average, lawyers win half their cases when they go to court, right? Because each side predictably is only going to win half the cases. So each side is going to win half the time. Our algorithms are predicting about, with 90% accuracy, who's going to win those cases. And we do it by looking at how the courts map those facts onto particular legal outcomes. And we run our algorithms on those fact outcome pairings. And the system trains itself on how courts are actually doing this. We're not training the algorithms on the legal reasoning part. We're essentially starting with the facts and the outcomes and allowing the system to figure out what facts are driving the courts to which outcomes. And so you'll see this shortly when we get into our example. Okay, so there are different ways that you might think about the legal research path that individuals go through. In the old analog world, to find relevant cases, you'd have to go to the law library, grab physical volumes that appear to be relevant. Maybe there'd be manual indices of subsequent citations of those cases, and you go there and you can find the subsequent cases that cite to those earlier cases. A hard copy noting up process. Using digital, that became a lot faster. You could use a keyword search to find relevant cases, and then you could automatically note up the statutory section or relevant cases that you're working with, and it'll automatically present you with all the cases that cited to it. In the computational framework, you can find all the cases kind of automatically that share the same footprint as the case that you're looking at. So what you do is you choose the classifier for your legal problem. We'll do this shortly. Enter all the facts, and it's going to locate those cases that have the greatest factual similarity to the case that you've actually essentially entered into the system based on your assumptions. And we could go through this. I think it's going to become very clear when we get into actually analyzing the situation. I think the key thing for us is that we basically turn the legal research process from one where essentially those materials are in the driver's seat. So the materials are sitting there static, inert, in stacks, they're physical volumes. And the legal researcher or the tax researcher is going into those materials, heading into the stacks and trying to read them, find them, extract the information, and then the human is taking that information and applying it to the problem that they're confronted with, they're trying to solve for a client or maybe for themselves. In the computational world, the thing is different. So the skill set is really about issue identification. You have to identify the issue, then you go into the system, and the system starts eliciting the information necessary from you in order to provide a good prediction about how the situation is going to turn out. So it turns it around. And the role of the human in the process is less about becoming an information collector and synthesizer directly, and more about identifying the issues and then interacting with the tools in an intelligent way. And so this is how the computational approach is going to really change legal research. And I hope to give you a sense of that in a moment. Okay, so what are people using Tax Foresight to do right now? They're using it to produce the highest quality advice. So one of the things that we hear from our clients is, I can use this, it cuts down on the uncertainty that I have about the materials, it synthesizes everything. I have confidence that it's looking at all of the relevant materials, so I'm not missing anything. It's allowing me to really confidently double check my legal research, and it's faster, so it's conducting smarter, more efficient research, cutting down dramatically on the time it takes to produce a higher quality output. So it's a better output and it's produced more quickly. Very important. It allows users to quantify the risk that clients may be taking, either say in a decision about whether to engage in a voluntary disclosure. So should I voluntarily disclose this? What are the risks that if this were challenged, that I might be in trouble? And so just trying to calibrate what are the risks, what are the upsides of a voluntary disclosure, for example, or even just simple stuff like this case that we're going to talk about today involving securities trading. There would have been a moment when this taxpayer was confronted with this reassessment, went to see an accountant or a lawyer and said, so should I challenge this, or what do you think my chances are? And that individual would have gotten certain advice from that lawyer or from that accountant. And it can be very, very difficult for a lawyer and accountant to give a really confident prediction. It's very unlikely that it's a 68% chance that you'll win, for example. They won't say, they'll say, well, I think we have a pretty good shot. I think it's a strong case. It's not impossible that the Crown may win, but I think we have a good shot. That can happen for sure, and that's usually the sort of advice that people get. Some accountants, some lawyers just always have a stock answer. They say, I don't know, it could go either way. It's kind of 50-50. It's really hard to say. It depends on the judge. It depends on the lawyer on the other side. It depends on how well the witnesses perform at trial. It's really hard to say which way this is going to go, which is kind of a meaningless answer, because surely in most cases, they're going to be a better answer than the other. And clients want to know what that is. And so that's often a very frustrating answer. The 50-50 answer is a frustrating answer for clients to hear. And then the other thing is it allows individuals to get an independent analysis. So it allows them to check their intuitions, double check with a completely different way of arriving at an answer. We humans are awesome at synthesizing our understanding on a limited set of inputs. So each individual lawyer or accountant will have only read a small subset of the cases on a particular issue, and still in a lot of cases be fairly well calibrated to what the courts are doing. But it's hard for them to demonstrate that that's an independent or objective view of the case law. And so that's something that Tax Foresight can help with. It's basically presenting someone else with the results of your analysis and say, hey, look, I ran this analysis. These are the assumptions that I made about the facts, and here's what the system's saying about the likelihood of this outcome arising. And anyone using Tax Foresight is going to get the same prediction if they're entering the same assumed facts. And so it's a way to basically verify and also communicate to others in a credible way about the strength of one's case. And that's important whether you're acting for the Crown or whether you're acting for the taxpayer. Being able to show that it's independent, it's not biased, is a really powerful tool of persuasion. It shows that you've done your due diligence, and it's not just you saying so. It's a system that's been trained on all the case law in the area. Okay, so let's jump into our specific question for today, which relates to securities trading. So securities trading comes up all the time, and under the Act, we know that there's a contest in a lot of cases where facts could be treated either as giving rise to business income, or they could be treated as giving rise to capital gains. And the underlying facts can often support the differing characterizations by the courts, and they depend on really fine distinctions in the facts. What actually happened? Who is the taxpayer? How frequently did they trade? What were they trading? What was their intention when they traded? Why is it that they sold a particular security or a particular asset? What's actually going on here? And what's the underlying property? So you may get a different result if you have somebody buying and selling real property, that is real estate, or buying and selling securities, or buying and selling commodities or something else, or cryptocurrencies, for example. A lot of it is going to depend on very, very contextual factors, which makes it really, really difficult to provide confident advice unless you've read all the cases in the area and you're confident about your ability to synthesize what all those cases will provide in an unbiased and objective way. And that's a tall task for anyone. We humans have the neurology that we have, the psychology that we have. We engage in filtering of new information. We have confirmation biases. We suffer from motivated reasoning. If you're providing advice to a client, often you want to provide the advice that client wants to hear. And if it's a competitive market for providing advice, you might be motivated not to tell them the whole truth or to shade your advice in the way that you think your client wants to hear. And it can happen very subconsciously. And so one of the ways to protect you against this, and really high quality, sophisticated counsel have been doing this for a very long time, and sophisticated accountants have been doing this for a long time, is to take a step back and say, okay, is this legit? What would the best argument be on the other side? Am I getting this right? Am I thinking about this clearly? What are the risks? What are the exposures? And so that's second nature to a lot of seasoned practitioners. Tax Foresight can help junior and moderately well experienced practitioners get to the same level of conviction and also substantiation of their positions very, very quickly. So we're going to be looking at this distinction. It matters a lot when you're talking about buying and selling, for example, securities that are not Canadian securities. So there is this rule in the Income Tax Act that if you're buying and selling Canadian securities, you can make something called the Canadian Securities election under subsection 39(4) that will allow you to treat all of your transactions in Canadian securities, for example, as capital gains. But once you get beyond Canadian securities, that Canadian securities election doesn't apply. And there are other things that might cause that Canadian securities election not to apply to a particular taxpayer. So one is that's not actually a Canadian security. So if it's a US stock, it won't apply there. If it is the case that you're a trader or dealer in securities, then you can't make use of that election. Oftentimes, when the minister is trying to characterize a taxpayer as engaged in the business of buying and selling securities, they are saying essentially you're a day trader or you're a frequent trader in these kinds of instruments, and as a result, you need to be treated as a trader. And traders who do this professionally as business are taxed on the basis that those gains are business income to them. And so to restore parity between those who do this on a full-time basis professionally and are therefore taxed as business people earning those income, or more often maybe incorporated. So you're working for a business whose business it is to buy and sell securities, a finance company of some kind. Those gains for sure are going to be taxed as business income. And to have parity between those financial companies, financial institutions, and those who are trading on their own account, if you're sophisticated and you trade a lot, you should be treated philosophically under the Act in the same way as those businesses and taxes business income. On the other hand, there's a long line of cases, a long history that says, oh, corporate securities are the sorts of things that give rise to capital gains. This goes way back to a case called Irrigation Industries, decided by the Supreme Court a long, long time ago. And in Irrigation Industries, the Supreme Court split very closely. I believe it was 3 judges in the majority, 2 dissented, and said, no, these securities are corporate securities are the kinds of things that are typically an investment. They give rise to dividend income. You buy corporate securities with a view to earning that dividend income and earning a return from them on the basis that they're an investment. And so there is this idea in the law that corporate securities are investments, but all that changes when the way that you're going to make money from holding these securities is by riding market fluctuations rather than holding them with a view to receiving dividend income. So if you're talking about someone who's in and out of the market multiple times a day, for example, making hundreds or thousands of trades a year, that person is a trader. So they're not holding those securities with a view to earning dividend income. They're trading the fluctuations, and they're going to be treated by the courts fairly reliably, I would say, as being a trader in those securities and treated as business income, those gains or losses from trading. In between cases are challenging. So if you buy and hold a basket of securities and sell them after holding them for years, that's clearly going to give rise to a capital gain in the ordinary case. If you're in and out of the market hundreds of times a day, that's typically going to give rise to business income. And so it's in between those extremes that we get really challenging cases. And so we're going to turn now to this case. So it's a case called Foote, just decided last year by the Tax Court of Canada. It's a real case. And we're going to see how this might be addressed by the securities trading classifier on Tax Foresight. So here's the deal. Mr. Foote was employed as a co-head of institutional trading at a finance company. Lots of experience and expertise in the investment industry. He earned a lot of money, around $800,000 a year in this position. And in addition to the work that he did in his official capacity as an employee of this finance firm, he also had 2 trading accounts, one for Canadian positions and one for US positions. And essentially, he picked relatively risky securities. He thought that they had the prospect for 30% returns, and he traded for a number of years. In 2009, he sold all of the holdings in both of these accounts, converted them into cash, and retired a mortgage. Later in 2009, he purchased and sold stocks of 34 different companies with a total cost of $2.5 million. So 38 purchases, 50 sales. So he's in and out at least some of the time with respect to the same companies, and had a total gain of $550,000. And so 88 transactions in 2009, earlier years, about 30 transactions in and out. So trading fairly frequently, on average, several transactions a month, but not over the top. So some people trade, many dozens of times a week. This was not Mr. Foote. So compared to some people that Mr. Foote probably knows, he's not trading a massive amount. He's trading some. And so he treats these gains as being on account of capital, and the CRA reassesses him for the 2009 taxation year and says, the $550,000 that he gained through these transactions should be considered income from business, not capital gains. So let's see how you might address this using Tax Foresight. So I'm going to jump into Tax Foresight here. I'm going to log in. Okay, so we're at the login screen for Tax Foresight. I'm going to pull up the securities trading classifier here by just typing securities into the quick find menu. And we can see a few things here. We can download the questionnaire that has all the questions. If you're doing client intake, you'll want to do that. You might want to pin it to your favorites. And then we've got the classifier and the case finder. What I'm most interested in right now is what would happen if this were to go to court. So I'm going to use the classifier. What the classifier is going to do is basically ask us a whole bunch of questions about the situation, elicit our responses, and then give us a prediction about what a court would do with respect to Mr. Foot's approach. Okay, so just at a glance here, what do we have? Well, we're told it's a securities trading classifier. We haven't answered any of the 21 questions yet. We're going to answer some questions first, apparently, about the taxpayer, then about the taxpayer's conduct, about the transactions, the nature of the trades, then we're going to get the result. Okay, so hopping right in, what best describes the taxpayer? Mr. Foot's an individual. Does the taxpayer's ordinary occupation or business involve trading or dealing in securities? Yes. I mean, he works at this finance firm, and this is going to be an important aspect. What's his ordinary occupation? Co-head of institutional trading. Which of the following best describes the taxpayer's knowledge of the securities market? Experienced. So if I have any debate about novice, intermediate, or experienced here, I can just hover over this little I. It's called a tooltip. And the tooltip is going to tell us that here, someone who is experienced deals with securities either as a professional or on a frequent basis. Okay, so yep, good to go there. What amount did the taxpayer earn from securities trading in the past 12 months? So let's pretend we're answering this for the 2009 taxation year. We'll say $550,000. What amount of income did the taxpayer earn from sources other than securities trading in the past 12 months? Well, let's say $800,000. Let's assume there's no other sources of income aside from the securities trading activities and the employment income that Mr. Foot earned. Okay, click next. How many hours per week on average does a taxpayer spend researching the securities market and investigating potential purchases? So a lot of time, this is his full-time job. Some of that is going to spill over to his personal life. So we're going to say 30 hours. How has the taxpayer characterized gains and losses on securities in previous taxation years? He's consistently treated them as being on account of capital, so we'll say that. Has the taxpayer completed a T123 form electing to essentially take the Canadian securities election? I think very few people actually do. So let's say no, or let's just say don't know, because I'm not 100% sure. Let's just say don't know. We can come back and change 2.3 if we want. How many securities transactions has the taxpayer completed in the past 12 months? We know in 2009 he completed 88 transactions. In the past 5 years, how many has he done? Well, we have 30 per year in previous taxation years. So let's say 4 times 30 is 120, 120 plus 88, let's say ballpark 208, okay? On average, how many months does the taxpayer hold similar securities from time of acquisition until disposition? So we were told in 2009 it was on average about 50 days. So I'm going to say 1.5 months on average. What percentage of the total market value of the taxpayer's current securities portfolio is financed on credit? Let's say 0. It's all no margin buys. It's all just fully bought on cash terms. Okay. What best describes the transaction in question? Well, he's holding and trading a portfolio of securities, right? He's got 34 different issuers that he's trading in. Here, he's trading in shares of companies. Some of the securities are Canadian securities and some are US securities. Did the security or securities yield income? This is debatable. I'm going to say some of them probably did. I'll say yes. Again, this is the sort of thing that we can come back to and change. I don't think he was selling these things short. He was engaged. All of his positions were long positions. At the time of acquisition, how long did the taxpayer intend to hold the securities for? Less than 1 year. He knew that he was in and out of the market a lot, had a feeling about momentum and other things. And how many months did the taxpayer actually hold the securities in question? Again, about 1.5 months. What was the total gain or loss from the disposition of the security or securities in question? Again, this is the same answer, $550,000. So we've answered, now we can see we've answered 21 out of 21 questions. And I'm going to ask you to, in your own mind, what do you think the probability is here that these transactions are going to be treated on account of capital? So is the taxpayer's position going to be sustained in the tax court? As I mentioned, this is kind of one of those difficult intermediate cases. So things that go against him, he's an investment professional. He earned a lot of money buying and selling these securities in 2009. And he's got a moderate level of activity. There's certainly people who trade more, and then there are certainly people who trade a lot less. The question is, what does this net out for Mr. Foote? So jot down a number, or if you're honest with yourself, kind of imagine your number. What percent chance do you think this is going to be treated as being on account of capital? Okay, I'm going to click compute here, and we're going to see the result. Okay, pretty clear indication here that the courts are not likely to treat these gains as being capital in nature. Instead, it's very likely that a court is going to say these gains are income from business. So 86% chance is how the algorithm is characterizing the outcome here. So what's the explanation? The explanation is essentially casting into plain language what the algorithm is considering. So this explanation is tailored very much for how we answered the questions throughout the questionnaire. So you'd get a different explanation depending on how we characterize the facts for the system. So it's entirely based on how we framed the situation here. For the system, if we go back and change some of the answers, which we'll do momentarily, we'll get a different explanation. Here we see the most similar cases decided by the courts, and this is based on the factual fingerprint of the case. No surprise here, Foote comes up as the #1 result. If we hover over the bar here, it tells us all the things that are similar about the Foote case. This is essentially the Foote case. So the system's saying this case is a lot like Foote, and in fact, it is. And there aren't that many cases that are very similar to Foote. So it's really picking up on the similarity there. Casually, you can look at this list and say, hey, look at most of these cases are being treated by the courts as giving rise to business income. There are a couple that went the other way, went on account of capital. So that kind of contextualizes that 86% finding coming out of the classifier. It makes sense in that light. Here are the leading cases in the area. This is the irrigation industries case that I mentioned earlier. If I click on any of these links, it'll take me out to TaxNet Pro. I can read the full text of the judgments there. At this point, I can do different things. One thing I could do is share this result with someone. So I'm going to email it to myself. Check this out. And I'm going to share that with myself. What I'll get is an email with a PDF report attached reflecting the outcome of this classification. So to see what that report looks like, I'll click on report. I can download it locally to my machine here, and I'll open it up, and we can see very, very convenient. I've got the outcome, the classifier, the result, the confidence, the explanation of the result. I've got links to all the most similar cases right there. I've got the references to the leading cases and other materials here to read. And very importantly, I've got all the questions and answers that I've assumed here to be true. So if a judge found all of these facts to be consistent with how I've treated this, it's very likely that the court would come up with this outcome. So this would be very, very helpful. If I were advising this taxpayer, I'd say, hey, look, we could go to trial. I've presented the facts as sympathetically as I could, and it doesn't look good, but we can do some math about figuring out whether it makes sense, or perhaps we should just settle. Maybe we should figure out the best terms to settle this case. And then we're asked for some feedback. Do you agree with the outcome or not? One of the really powerful things is we can go back and change some of these answers, right? So let's go back and say, yes, the taxpayer did elect in one of these things. This is not only obviously going to affect the Canadian securities, it wouldn't affect any of the US issuers that the taxpayer's trading in, because those aren't Canadian securities. We could change that to yes and see how it influences the answer. Not very much at all, because those elections are only effective if they do actually qualify. Okay, what if we go here and change? What if we want to say, I know this taxpayer had this position in terms of institutional trading, but it was really only intermediate. So saying experienced might be an overstatement. It's hard to believe that would be true in these circumstances, but let's just say for the sake of argument. So that makes a difference. So if the court's saying, yeah, he's of intermediate experience in the markets, sort of knows what he's doing, but isn't really that experienced, still, much more likely than not that the court would say income from business, but it's not a slam dunk. What if his ordinary occupation wasn't at all this? So what if we say janitor and novice? So what if we change the circumstances here a little bit? Let's say he has $80,000 in income, and let's leave the $550,000 the same. Like, let's just say, he got extremely lucky, but he was a novice, he got lucky. What would the court say in those circumstances? Wow, dramatically different. So if you change the facts, it's going to lead to a very, very different result. And so what you see here is the sensitivity to the context. If someone is a finance professional, very, very experienced in doing this idea that we should treat them more like a business that is engaged in buying and selling securities seems to be very compelling for the courts. If we change the context in which someone is working, we make them a janitor, it changes the result really quite a bit. So very cool to be able to stress test this. What if we have a janitor, I don't know if this is realistic, who makes $800,000 a year? What does that income do? How does that influence the result? Does it influence it very much? No, not really. So it's not the income factor, at least not in these circumstances, that's driving this outcome. What if we say intermediate? And what if we say, I don't know, $100,000, or maybe let's change it to $150,000. What's this doing? Okay, on account of capital. So what you can do is really kind of get into the context of a particular case, what's really driving the courts in this area, and you can really explore that space. And so lots of people are using Tax Foresight to explore lots of different scenarios and try to figure out a positioning strategy. How do we want to position the facts of this case when we're advocating for a particular outcome? So the Crown is doing this. How do we present the government's case in the best possible way, given what we know about the arc of the case law? And tax litigators on behalf of taxpayers are doing the same thing on the other side. They're often meeting in the middle, of course, in settlement negotiations, but it allows both sides to have more confidence about the settlements that they're entering into. Okay, a couple other things that I want to show you here. One would be, let's go back to the securities trading classifier, the case finder. So what's the case finder all about? What's happening here with the case finder? Well, the case finder is a way to find the cases that you really might want to locate for your own advocacy purposes. So if you're trying to position your client's case in a particular way, you're looking for that case that you can use to provide additional support for an argument that you may be making. One of the ways to find those cases, of course, as we've been looking at the classifiers, is with those list of similar cases, and you get a brief outline of how those cases turned out. You get the one word, either business or capital, there in that list at the end of the classifier on the result screen. Here in the case finder, you can search by all the different facts that you think are really important, so including the outcome. So if I were advocating for the taxpayer here, I might say, please system, show me all the cases that went on account of capital. Show me all the cases where the taxpayer was an individual and they went on account of capital. So we can see lots here, right? We can show up to 20 cases at a time. So that's great. Now let's see cases that went capital, where they involved an individual, where the taxpayer's occupation involves trading or dealing in securities. Okay, I have just 2 of these cases that have ever been decided in the data set. So one's from 1979, one's from 1964. Right now, there's no easy way, aside from using Case Finder, to locate these cases very, very quickly. So as an advocate, what I'm going to do is say, okay, I need to find those cases. I need to read those cases. If I click on the link, it'll take me out to TaxNet Pro. I can read the full text of the judgment, do the normal things that I might do in TaxNet Pro, note up those cases, look at the history and subsequent treatment. But I can use these cases as a resource for finding out what courts find really compelling about those cases. Maybe I can identify in those cases things that I can say, yes, 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 here in this case, in Foot's case, we find similarities to McDonald or to Graham. And so in these cases, the taxpayer should be treated as if these gains are on account of capital rather than business. And of course, it's essentially anything that the classifier asks about that you can drill down into these judgments and find just the right cases for you. So this is really, really flexible, really powerful, and you can find those cases that you really want in the case law. Okay, that was very quickly. There are tons of different features offered on Tax Foresight now. We're coming up on 24 different legal issues that the system addresses. So we've been talking a lot about the securities trading classifier. Today, we've got a worker classifier, which will tell you whether a worker is an employee or independent contractor for tax purposes, an issue that comes up all the time. The question is whether a taxpayer is going to be taxed under sections 5 through 8 of the Income Tax Act as an officer or an employee, or under sections 9 through 37, which deal with income from business and property. So really, really important. And nowadays, in things like the gig economy, our Uber drivers, independent contractors, or employees comes up all the time. Residency questions often involve a gray area when you're trying to decide whether someone's ordinarily resident in Canada for tax purposes according to the common law test, or you've done that, you find that they are, but they're also possibly resident in another jurisdiction for tax purposes. How do you resolve that residency conflict under a tax treaty? And then you get into questions like, where's the taxpayer's center of vital interest? Again, a gray area question. We've trained the residency classifier on all of the cases that have drawn those distinctions in the Canadian court. So you can basically mine that resource and find out what the courts would likely do if it were to go to court. The gross negligence classifier is something that we developed by special request of a number of folks after we launched Tax Foresight a year ago. They said, Ben and others at Blue Jay, this is an amazing technology. If only you guys could produce a tool that would predict whether gross negligence penalties under the Income Tax Act would apply to a particular taxpayer, that would be extremely valuable to us, because it's very, very hard to predict what the courts are going to do or say with respect to these gross negligence penalties. And the minister is fond of applying these gross negligence penalties. So should we fight those or not? Is it likely that they're going to be added to the judgment of the tax court if my client loses? And so we built the gross negligence classifier. It's based on hundreds of cases, a really, really great tool for predicting how the courts are going to consider the application of those penalties. We set out long ago to build a GAR classifier. So we thought, it'd be amazing is if we could build a classifier for the general anti-avoidance rule that would predict whether a taxpayer has misused or abused the Income Tax Act or some other relevant enactment, including a tax treaty. And so we collected all the GAR cases. We thought, we're going to do this. We're going to use AI and machine learning. We're going to predict these outcomes in these GAR cases. And we couldn't get it to the level of confidence that we wanted to get it to. The courts are just not at a position where they've decided enough cases to provide enough information to these algorithms to get good convergence on what a court is likely to do with the GAR. So we've got a case finder. The case finder is awesome. For GAR, you can really find any GAR judgment that has just the attributes or the, relates to the provisions of interest that you want. You're going to make sure that you're not going to miss any GAR judgments if you use our GAR case finder. Sadly, we don't yet have the GAR classifier. It's technologically impossible, as far as I'm concerned, to have a GAR classifier that's 90% accurate at this point. And that's consistent with what you hear from practitioners. So you talk to tax litigators like, wow, GAR cases are really hard. If they're feeling dismissive, they'll call it a smell test. The misuse or abuse branch of GAR jurisprudence, they call it a smell test, and it's really hard to predict. Judges olfactory senses. We've got a whole bunch of income versus capital classifiers. We've been talking about the securities trading one. We've got one on real estate, buying and selling real estate. Is that on account of capital or on account of income from business? Intangible expenditures. So if you're buying something like a customer list or IP, is that currently deductible or is that a capital expenditure? And then the same thing with tangible expenditures, current versus capital for things like, I don't know, furniture or art or land or buildings or machinery. If you're buying something tangible, can you treat that as a current expense? And we've got classifiers and case finders for all of these income versus capital things. Sources of income, we talked about this worker classification. Windfall is a wagering activity. Poker winnings, are poker winnings taxable as income from business or are they personal? Business versus property, an important issue in a lot of context. Is income from a rental property business income? Are you actively managing that property sufficiently for it to be treated as business income, or is it a passive property income? Important question in a lot of contexts. We've trained this classifier up on all the cases. We've got a number of inclusionary functions. A navigator for taxable benefits. So this takes you through the rules-based way in which the CRA considers taxable benefits. So you can get an answer, what's the CRA's position likely to be with respect to a particular taxable benefit? And that's a navigator, so that's a rules-based approach. We've got taxable benefits, primary beneficiary. This is trained on all the case law. And here the question is a particular expenditure on the part of an employer to benefit primarily the employer or the employee? So for something to be a taxable benefit, it has to be the case that the primary beneficiary is the employee. Otherwise, it's for employer's business purposes, therefore not a benefit to the employee. And so this classifier and case finder will help you navigate through all those cases, get a good handle on whether a court would likely say that the taxpayer is the primary beneficiary in those circumstances. Shareholder benefits, same thing. Who's the primary beneficiary of various things that might be characterized as shareholder benefits? On the deduction side, we've got home office, classifier, case finder, capital cost allowance, navigator. So this is very cool. You answer a series of questions and it will tell you which class of property your asset likely lands under the regulations. And so you go through and you may answer as few as 5 or as many as 20 questions, and it works through the logic of the regs and will take you to a predicted class, and then you can go and double check and make sure that it satisfies that class. CCPC status, so this steps you through the logic and as to whether or not a company satisfies the definition of a Canadian controlled private corporation. Talked about residency already. Carrying on business, this is the threshold for taxation in Canada, both for income tax and also for excise tax purposes. And so this is a frequently arising question, lots of case law, lots of guidance on how to apply that, sometimes pretty confusing. We know the threshold for carrying on business is pretty low, but it's a question of interpretation. How do you interpret those things? And so carrying on business will help you figure that out. Where is the central management and control of a company? Again, this is kind of the common law residency test for corporations, also relevant for trusts, given recent Supreme Court of Canada jurisprudence here. Where is a corporation being centrally managed and controlled from? This classifier and case finder will help you figure that out. We've talked about gross negligence. Director's liability in the assessment period do the same thing as the other classifiers. Director's liability basically asks, can you look through the company and find the directors personally liable for failure to pay amounts required by the Income Tax Act or the Excise Tax Act? The assessment period operates similarly to the gross negligence classifier. Can the assessment period be extended by the CRA on account of misrepresentation on the part of the taxpayer? This classifier and case finder will help you figure that out. We talked about the GAR. And then we've got rollover eligibility navigators. Are you eligible for a rollover to a company pursuant to Section 85. And we've got a special one for partnerships and a special one for corporations and the relevant filings there, the relevant elections. Okay, so that's Tax Foresight in a nutshell, how individuals are using machine learning to essentially answer these kinds of questions. I'm happy to take questions now. I see that there are a number of questions here, so I'm just going to launch in and I'll answer them in order. If you have a question, ask it now, and I will pick up themes if there are multiple people asking the same sorts of things. We've got dozens and dozens of people online here, so please ask your questions. I'd love to engage with you here in this way. So I'm reading the questions now. What about an investor who hires an intermediary to do the hundreds of trades a day and trades and options as well? That's a good question. So if you're hiring an intermediary to do the hundreds of trades a day and trading in options as well, the question is how you want to characterize that situation. So are you going to characterize that essentially as an investment in a company, or are you going to treat that as essentially that trader working as an agent for the taxpayer? So that's a really interesting question. In those circumstances, I think you would probably, it would really depend on the structure of that agreement about who is this intermediary, and is it like I'm buying a mutual fund and this mutual fund is actively managing a portfolio of securities. I have no control over it. I've just bought this fund and it's in and out of different securities, or have I bought an index fund and these hundreds of trades are really just balancing the index fund to reflect what's in the underlying index? If that's what I'm doing, then that looks more like it's not really frequently trading. If on the other hand, I'm just basically delegating to someone who's going to be trading all the time, then I think you would go with what the prediction would be coming out of the securities trading classifier. But again, this is going to depend on how the courts want to characterize that circumstance. So if you're a novice who's hiring this person to do hundreds of trades a day, it comes down to how the courts are going to want to characterize. It's a really good question. I don't know that we've seen enough cases to really say with any confidence how the courts would analyze that kind of question. Okay, somebody has asked, who do you see as your primary audience for this service? Litigators? This is a great question. Certainly tax litigators are one of the primary audiences for this service, both in private practice, so in law firms, also for sure would involve litigators, and we have subscribers among many of the full service law firms here in Toronto and across the country in the major centers. They're subscribing to Tax Foresight, using it to inform their trial advocacy strategy. How do they want to position the facts? How do they want to present the case to the court and also to the Crown? So for sure litigators, but not only litigators. So these classifiers are very, very relevant as well at earlier stages. So highly relevant for the Canada Revenue Agency. If you are looking to improve the reliability, the consistency of the decision-making of the Canada Revenue Agency, Canada Revenue Agency has 40,000 employees across the country. Not all of them are lawyers. In fact, very few of them as a percentage are lawyers and would be conversant in reading the case law and really understanding the various aspects of the case law. And that's not to knock them. They work very hard and they try to get to the right answers. One of the challenges they have is the case law is really hard to synthesize. Even if you have unlimited time just for an individual human to work through that with a level of sophistication and come up with a really concrete prediction, it's really hard. One of the advantages of using this kind of software is it allows those individuals to very reliably get to a pretty good answer, a 90% or better answer based on the assumptions of fact that they make. And so you can imagine the CRA saying, okay, this is a tool that we just have to have It's going to improve the quality of the decision making. It's going to essentially make sure that we're not wildly off base with the way that we are reassessing taxpayers. And after all, that's what the tax administration is supposed to be doing, is administering tax law consistently with what the courts require. And if it's working that way for the CRA, it's no surprise to you. It shouldn't be a surprise to you that it's working the same way for a lot of folks who are tax accountants or accountants in private practice who want to provide quick answers, especially as we get into T1 season and T2 season shortly. Tomorrow's February, soon it's going to be March and April, and everyone's going to be rushing really quickly to get those tax returns filed. A lot of these characterization questions are going to come up repeatedly as accountants prepare tax returns for their clients. They can use Tax Foresight, get some immediate backup for the positions that they're taking. Boom, download that report, save it to the client's file, and just say, it's reasonable for us to take this filing position because we have at least a 30% chance of this position being sustained if it were to ever go to court. So let's just run with it. And it can speed up that process. They don't have to do research. They don't have to recklessly kind of make up an answer on the fly. They can do the research very fast. And as the CRA adopts the software, it's going to become the way in which these questions get talked about between government and accountants. So you're right, it does start with the litigators, and it does start with that very real dispute resolution process as between Crown litigators and private tax litigators. But as everyone does the backwards induction and it percolates back through the system, it should inform everyone's judgments about the tax positions they should be taking, either for government or in private practice. And so it's priced accordingly. If you have a small accounting shop, it's priced in a way that is going to be very attractive to you. You can access it, pair it up with a TaxNet Pro subscription, and you can access it fairly reasonably, and go from there. Okay, I think we have time for one more question. I see one just came in. It looks like an interesting one, so I think I'm going to take it. Would the software be able to predict whether the personal services business legislation would apply? Say a worker is clearly an employee, but the presence of his corporation starts to use his truck or tools in his corporation to reduce the personal services business risk. Will the software assist in determining personal service business concerns? Okay, so the personal services business rule, for those of you who aren't familiar with it, a personal services business is defined in subsection 125(7). And essentially, a personal services business is a business that's carried on by a company that is employing someone who's called an incorporated employee. And so basically, it's trying to capture those circumstances where someone would be an employee of an employer, but for that corporation. So if you ignored the existence of that interposed corporation, this person would be an employee, but they've basically created a company, put it in between themselves and that party that would otherwise be their employer. And because a company can't be an employee, when that employer company hires this interposed company, that interposed company can't be an employee, it's a corporation. And so an employee is an individual in the service of another party. An individual isn't a company. So the company can't be an employee. The company is definitely in business for itself. Now, what happens to that business being carried on by that company is, if it's treated as a personal services business, it's denied the benefit of the small business deduction, and it's denied the deduction of other amounts that might otherwise be payable to other parties other than the salary, wages, and the cost of benefits provided to that incorporated employee. So the answer is yes, you can use the worker classifier to figure out whether the personal services business rules apply, in the sense that you can answer the question, but for that interposed corporation, would it be reasonable to regard that incorporated employee as an employee of the hirer? And so that will tell you whether some of the conditions for a personal services business are satisfied. It won't tell you about the specified shareholder condition, and it won't tell you about the various safe harbors, including whether the personal services business has more than 5 full-time employees. So if that interposed corporation in between the employee and the hiring company, if it has 6 or more full-time employees, then the personal services business rule won't apply. The worker classifier isn't going to tell you that part, but it's a fairly clear, bright line rule. So you'll be able to know that for yourself. Okay, thanks for your patience. Everybody, I think we're out of time for today. Thanks very much. I love doing these webinars. We've got some future webinars planned. We're going to keep producing this content, keep answering your questions, keep telling you about machine learning and tax law. And I hope you'll join us next time. And I hope you found this interesting and engaging. Thanks very much and have a great week. Take care.